Good morning, everybody, and welcome to a new term of the Committee of Bar Examiners. Before we begin, can Ms. Wong please take roll?
Sure. James Bolton. Michael Cow.
Present.
Alex Chen. Mr. Chen. James Afting.
Present.
Karim Gongora.
Present.
Dolores Heisinger.
Here.
Judge James Herman. Michael Uferi.
Here.
Larry Kaplan.
Here.
Bethany Pick.
Present.
Vince Reyes.
Here.
Unfortunately, Judge Toriyaba just informed me this morning that she's not able to join the meeting, so she will not be attending this meeting. David Torres.
Here.
Alex Lawrence.
Here.
Great. And then Ms. Chair, Esther Lin.
I think he forgot me.
Oh, I'm sorry, Paul Kramer.
Here.
Thank you. So we have to take some matters out of order this morning to accommodate our presenters for the orientation. Public comments will be heard, but it will take place after our orientation. My best time estimate for the public commenters would be approximately 11 o'clock or so. And at this time, I'd like to welcome our new member to the committee. I'm not sure if he's been able to log on yet. It would be Judge Herman. He's a Supreme Court appointee, and we welcome him whenever he can join us. Also, I hope everyone has had an opportunity to look over the proposed subcommittee assignments for this year. And Ed Standards will be chaired by Paul Kramer and vice chaired by Dolores Heisinger. Examinations with James Efting as chair and Vince Reyes as vice chair. Operations and management will be Alex Lawrence as chair and Judge Tori Alba as vice chair. Moral character will be Bethany Peak as chair and Dr. Bolton as vice chair. The Committee of State Bar Accredited and Registered Schools will be represented by our member, Paul Kramer. Is there a motion for this assignment to be received and filed?
So moved.
Thank you. Moved by Dolores Heisinger. Is there a second?
Second.
And I can't tell who that was.
Mr. Torres.
Okay. Roll call vote for this, please.
James Bolton. Dr. Cow.
Yes.
Mr. Chen.
Yes.
Mr. Afting.
Yes.
Mr. Gongora.
Yes.
Ms. Heisinger.
Yes.
Judge Herman, are you present? Mr. Iseri.
Yes.
Mr. Kaplan.
Yes.
Mr. Kramer.
Yes.
Mr. Lawrence.
Yes.
Ms. Peak.
Yes.
Mr. Reyes.
Yes.
Mr. Torres.
Yes.
The motion passes.
Thank you. And now I would like to recognize the outgoing officer and member. So both Robbie Brody and Patricia Villalobos are unable to join us today, but I'd still like to take a moment to acknowledge both of their services. Patricia has been with the Committee of Bar Examiners for 6 years now, and unfortunately her term has come to an end. As for our former chair, Robbie, he guided us through our very first Zoom meeting, among with other crises that we had to deal with in our last term. He did so seamlessly and effortlessly, so it'll be hard to live up to the standard that he has set. Luckily for us, Robbie's term has been renewed, and we hope that he'll be able to join us next meeting in December. I'll need a motion to extend the committee's gratitude to the outgoing committee chair, Robbie Brody, and member Patricia Villalobos for their service on the committee, and that the following citations be presented to them. The citations presented to Robbie S. Brody by the Committee of Bar Examiners of the State Bar of California in recognition of his outstanding service as committee chair during the 2019-2020 committee year and his distinguished service to the legal profession in California. And a citation is presented to Patricia Villalobos by the Committee of Bar Examiners of the State Bar of California in recognition of her retirement from the Committee of Bar Examiners after 6 years of service and her distinguished service to the legal profession in California. Is there a motion?
This is Bethany. I'll move.
Thank you. And a second?
I co-second.
Thank you. Roll call vote, please.
Dr. Kao,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan, Mr. Kaplan,
Yes.
Mr. Kramer,
Yes.
Ms. Pig,
Yes.
Mr. Rios,
Yes.
Mr. Lawrence,
Yes.
Mr. Torres.
Yes.
The motion passes.
Thank you. And last matter to be handled before orientation begins is we have the meeting minutes from our August 21st and 22nd meeting. Is there an approval or a motion for the meeting minutes to be accepted? And only members who attended the meeting should vote yes or no. So members who did not attend, please abstain. Is there a motion?
I move to accept the minutes.
Thank you. And that was a motion by Vince. Is there a second?
Yes.
And I can't tell who that was that just made the.
Kao,
Thank you. So roll call vote, please.
Dr. Kao,
Yes.
Mr. Chen,
Yes.
Mr. Efting,
Yes.
Mr. Gongora,
Yes.
Ms. Heisinger,
Yes.
Mr. Iseri,
Yes.
Mr. Kaplan,
Yes. Yes.
Mr. Kramer,
Yes.
Mr. Lawrence,
Yes.
Ms. Pig,
Yes.
Mr. Rios,
Yes.
Mr. Torres.
Yes.
The motion passes.
Thank you. So right now we'll begin our orientation.
Right. I will start that off. Good morning, everyone. As we do on an annual basis, the October CBE agenda has a space reserved for an orientation to the various functions that are carried out by the Office of Admissions. So today we'll be hearing from each of the program managers on their corresponding areas. If there are any questions as we're going through this, please feel free to raise your hand. And we'll start with the first slide so we can talk about the areas that we'll be covering. We are going to be covering the admissions overview, a conflict of interest, the legal authority governing the CBE, go over the functions of exam development, grading, the legal authority governing testing accommodations, operations and management, moral character, and law school regulation. One thing I wanted to mention about this Corey is we will, as you recall, Each of you are required to have a background check, and so this includes fingerprinting and a training on this criminal offender record information, to training on how we handle this information, the confidentiality, record keeping, and safety protocols around this information. We are skipping this section because each of you have been trained. Dr. Cow and Judge Herman, who has not joined us yet, but will have that conducted separately. So we're going to skip these, if you can, Kim, until we get to the next section. It starts with just one more. There we go. We're going to, Audrey Ching, our Assistant Director, will be kicking this off.
Good morning, everyone. Amy always has her middle initial. Mine is B, if you want to know. So good morning. These we're going to go over sort of first the entities overseeing our work in the Office of Admissions. As you can see in the slide, the Supreme Court, the Legislature, the Board of Trustees, and of course this group, the Committee of Bar Examiners. So this is the org chart for the State Bar. Again, the Board of Trustees, our Executive Director Interim, Donna Hershkowitz, and then you can see where admissions is. It's in the Programs Division. It's one of the programs of the State Bar, along with Access and Inclusion, Attorney Regulation, and Professional Competence, as you can see, us sitting as one of the programs right there under Donna Hershkowitz, whose permanent position was as the Chief of Programs. So the next slide will be how we're sort of in our own department what the org chart is. So Amy obviously is the director. I'm the assistant director, working with operations and management, law school regulation or ed standards, legal specialization, and then Amy directly working with examinations and grading, moral character, and you know, Kim and all her work with Kim and Devin on all their work here with the CBE members. So the Committee of Bar Examiners, 19 members, 10 lawyers appointed by the Supreme Court, and 9 public members. You're all serving 4-year terms. We have 4 committees, as we saw on the prior slide, covering educational standards, examinations, operations and management, and moral character. We also have law school committees. Actually, this is the old term for the law school committee, and Natalie will go into this more in depth about what CS Bars covers now, and the Law School Council. Projects for this upcoming year, the Blue Ribbon Commission and differential item functioning. And Amy, if you want to cover those more, we'll cover those also later in our staff reporting.
Right. So Caroline will cover our conflict of interest policies.
Thank you. And I'm hoping that my internet connection stays active throughout this presentation. It hasn't been a problem, and then it just strikes for some reason. Let me also shut off my fan. Don't want too much background noise. Okay, so most of you have already gone through the conflicts of interest presentation, but it's always good to get a refresher because these rules are pretty detailed, and I would encourage all of you to review each of the statutes and policies listed on this slide here. That would be the CBE Conflict of Interest Guidelines, the Conflict of Interest Code for Designated Employees of the State Bar, which applies to the CBE, Rules of Procedure of the State Bar, Rule 3101, Business and Professions Code sections 6036 through 6038, and portions of the Political Reform Act of 1974. The violations for conflicts of interest incurred to the member directly, and they can include personal fines, removal from the committee, disqualification from holding public office, and even criminal sanctions. The Committee of Bar Examiners has developed its own conflict of interest policies that are set forth in the Committee of Bar Examiners Conflict of Interest Guidelines. These have been adopted by the CBE, and basically they set forth the procedure for determining if recusal is required. It also restricts certain activities of former CBE members, and I'll go into detail in a few slides. Conflict of interest code for designated employees of the State Bar is adopted annually by the Board of Trustees, and it's been determined to apply to a number of sub-entities of the State Bar, including the CBE. So how do you identify a potential conflict of interest? If you think you might have a conflict, either personal or financial, you should disclose the potential conflict to Amy as soon as possible. Those conflicts would include significant family, professional, business, social, political, or other relationships. Oh, sorry. I'm hearing some background noise and I just want to make sure it's not a question. No? Okay. It could also include political or other relationships, adversarial or allied, direct or indirect, with an applicant or petitioner. And it covers any type of current or past relationship with a law school or bar review course other than as a graduate. So as you can see, I mean, it's a pretty broad definition of potential conflicts, and you want to err on the side of caution in disclosing to Amy any potential conflicts so that OGC can give you an opinion as to whether there's an issue. Committee members must first disclose a conflict when it arises. A member required to disqualify himself or herself because of a conflict of interest discloses the interest, that's to Amy, withdraws from any participation in any matter relating to that particular applicant or person, refrain from attempting to influence another member regarding decisions about that applicant or person, and refrain from voting on any decision making that the committee is engaging in with respect to that applicant or person. It's sufficient for the purposes of this section that the member indicate only that he or she has a disqualifying financial or personal interest. Okay, so if you have a personal or financial relationship with a specific applicant, and after consulting with Amy, there's a consensus that the relationship could unduly influence you, or there could be a perceived conflict of interest, then you must recuse yourself from all activities that may be associated with the following: the processing of that applicant's application for membership or petition, for licensure or petition. And in order to do that, it's looking a little bit different on Zoom these days, but traditionally in our in-person meetings, you would just walk out of the room and then someone would come and grab you when the discussion was over. On Zoom, we're asking that members just drop off the call, whether in open or closed session. And in open session, they're permitted to stay as a member of the public. They just can't participate in the discussion. In closed session, they have to drop off. And then somebody will just ping you and let you know when it's okay to come back in. An applicant taking an examination administered by the committee. So, sorry, this is another category of potential conflicts or potential situations in which you need to recuse yourself from matters relating to a particular applicant. So if an applicant you know is taking the examination, then you have to recuse yourself from the development, administration, and grading of that examination, and must leave the room if matters are being discussed. A committee member who has been disqualified from an activity is not precluded from providing information concerning an applicant in the form of providing information in a confidential questionnaire. It looks like we skipped one slide. Okay. Next one. There we go. Prohibited contact with law schools. So while serving as a member of the committee, you must refrain from personal contact with law schools regulated by the committee. That's the CALS and registered law schools, including accepting meals that are paid for by the school. There is an exception for meals scheduled in conjunction with the regular visitation to the school, a notice meeting of a group of law school representatives, or when making a presentation to the school on the committee's activities. We're not doing a lot of in-person meals together these days, unfortunately, so I don't anticipate this one coming up anytime soon. There's also a prohibition on representation during your term of office for 6 months following the end of your term, and a lesser restriction thereafter. So during your term of office, You shall not represent a party in a matter which involves the regulatory jurisdiction of the state bar and in which the party's interests are adverse or conflict with the state bar's regulatory interests. For 6 months following the end of the term, you're not to represent a party in a matter which involves the state bar's regulatory jurisdiction and in which you had supervisory responsibility. And after 6 months, you're not to represent a party in a matter which involves the state bar's regulatory jurisdiction and in which you personally and materially participated during the state bar service, during your state bar service, or which involved material confidential information to which you had access. There's also a restriction of activities, not just legal representation of former CBE members. For 12 months after expiration of their term, former CBE members must not seek to perform or perform any business with the CBE for monetary gain or act as an agent, attorney, or representative for compensation by making an appearance or communication before the CBE, state bar employee, or state bar court for the purpose of influencing official CBE or state bar action. Obviously, there's an appearance of conflict with this type of activity. The Conflict of Interest Code for Designated Employees, which I mentioned is adopted annually by the Board of Trustees, adds to the rules regarding conflicts that a CBE member is disqualified from participating in decisions with a reasonably foreseeable materially financial effect on the member, the member's family, or the member's financial interests. The code requires CBE members to file statements of economic interest, which we call Form 700s, disclosing only those financial interests, if any, that would result in disqualification under the code. The code prohibits CBE members from accepting honorariums of certain gifts from sources upon which CBE decisions would have a reasonably foreseeable material financial impact. If you're disqualified under the code for designated employees, you must not make, participate in making, or attempt to influence any CBE decision that you know have reason to know will have a reasonably foreseeable material financial effect, distinguishable from its effect on the public generally. And that would be on you, your immediate family, any business entity in which you have an investment or other interest worth $2,000 or more, any source of income, including gifts aggregating more than $500 over 12 months, and any business entity in which the member is a director, officer, partner, trustee, employee, or manager. There's also a prohibition on accepting certain gifts. So you may not accept an honorarium if you would be required to disclose it on your Form 700, which again, the standard there is material financial effect that's greater than on the public generally. And you may not accept gifts valued at more than $500 if you'd be required to disclose them on the Form 700. Form 700 reporting. So you must fill out a Form 700 upon assuming office and then annually thereafter. I'm not exactly sure when we have members submit, but hopefully an email reminder will go out about that. You'll receive the forms and then specific instructions from State Bar staff. And of course, if you have questions, you can direct them towards Amy and she can follow up with me, or you can direct them to me if you like. You need only report a financial interest if during the reporting period it's grounds for disqualification. And again, that's the material financial effect standard. Form 700s are subject to public information requests. So you might want to use the State Bar's contact information or your business contact information. The attorney members, that's maybe what's public on the State Bar's website rather than your personal contact information. I think we're reaching the end of this presentation, which is good. So contracts. Covered individuals shall not be financially interested in any contract made by them in their official capacity or by any body or board of which they are members. One conflict can disqualify the entire board. I haven't seen something like this come up in my time, but just something to be aware of. Okay, so I didn't realize I had 2 right in a row, so you're stuck with me for another another few minutes. Next presentation is just a very basic overview of the legal authorities that govern the Committee of Bar Examiners. Amy, are we going to take breaks or anything? I mean, we don't need one now. I just was wondering, like, if do we need a break for questions after presentations or anything? Should we just keep rolling?
No, if anybody has a question, I asked everyone to raise their hand if we need to pause. Okay. And, but the idea is to have the orientation. I think there's a pause after this. We're going to move into, I believe, O&M, and then you're also at the tail end of testing accommodation. So
okay. I wish I could change my view so that I could actually see oh, there we go. Okay, that's so much better. Now I can actually see people's faces instead of just the PowerPoint.
And you know what? If you want, I could alert you if anybody raises their hand.
Yeah, that would be great.
Okay. All right, will do.
Thank you. Again, this is just a brief presentation, an overview of the legal authorities that govern the Committee of Bar Examiners, and it's sort of a complicated labyrinth of different authorities. So we'll begin with the head honcho, the California Supreme Court. And the California Supreme Court maintains inherent and exclusive jurisdiction over the practice of law in California, which includes attorney admissions matters as well as disciplinary matters. The state bar serves as the administrative arm of the court for admissions matters and acts under the authority and at the direction of the court, and of course also the Board of Trustees. And the CBE acts exclusively under the authority delegated to it by the Board of Trustees, and under that authority has been delegated the task of administering the requirements for admission, examining applicants for admission, and certifying to the court for admission applicants who fulfill the admission requirements. The Supreme Court appoints 10 members to the CBE, each for a 4-year term. At least one must be a judicial officer of California, and the rest are licensed California attorneys. One of the attorneys shall have been admitted to the practice of law within 3 years of their appointment. The court may reappoint a member to serve no more than 3 additional full terms and may fill any vacancy, and it must make its appointments from a list of candidates nominated by the Board of Trustees pursuant to a procedure approved by the court. This is just an excerpt from Rule of Court 9.5. All state bar rules adopted by the State Bar Committee of Bar Examiners pertaining to the admission to practice law must be approved by the Board of Trustees and then submitted to the Supreme Court for its review and approval. So, the way that works in practice is the CBE votes to recommend adoption of a rule or a rule change to the Board of Trustees, and then the Board of Trustees either adopts or rejects the recommendation, and then that goes on to the Supreme Court for approval. The legislature also governs certain activities of the state bar. The California Supreme Court has traditionally respected the exercise of that authority by the legislature of a reasonable degree of regulation of the legal profession and practice of law. It does not displace the Supreme Court's inherent jurisdiction over the practice of law. The legislature created the state bar, a public corporation, when it enacted the State Bar Act in 1927. And the State Bar Act, of course, establishes both the Board of Trustees and the Committee of Bar Examiners. The Business and Professions Code sections, the ones excerpted here, are part of the State Bar Act. It begins at, I think, around 6,000. The State Bar Act requires that CBE have 9 public members in addition to the 10 attorney members appointed by the court, and they can never have been licensees of the State Bar or admitted to practice before any court in the United States, each serving a 4-year term. 3 are appointed by the Senate Rules Committee, 3 are appointed by the Speaker of the Assembly, and 3 are appointed by the Governor. The public members have the same rights, powers, and privileges as any attorney member, except that a public member shall not participate in the drafting of questions submitted to applicants on the California bar examination. The State Bar is governed by the Board of Trustees, which I mentioned a few slides ago, which is charged with the executive function of the State Bar and enforcement of the State Bar Act. The Board of Trustees is empowered to formulate and declare rules and regulations necessary or expedient to carry out the act. And it may establish the Committee of Bar Examiners, of course it has done so, having the power to examine all applicants for admission, administer the requirements for admission, and certify applicants for admission. Subject to the approval of the Board of Trustees, the CBE may adopt reasonable rules and regulations as may be necessary or advisable for the purpose of making effective the qualifications for admissions. This is sort of, I think this is with respect to guidelines mainly, which do not need to be approved by the Board of Trustees in order to take effect. And on November 4th, 1981, the Board of Trustees passed a resolution declaring that the CBE must comply with all Board of Trustees policies, including but not limited to contract, fiscal, and grant policies and personnel-related policies. And of course, we just covered all the conflict of interest policies that apply equally to the board. Okay, so finally, we have our own set of rules in addition to the Supreme Court rules and the legislature's rules. The State Bar has its own internal rules about the Committee of Bar Examiners. All State Bar committees have only the powers, duties, and authority delegated to them by the board, subject to its supervision and control, and the board reserves authority over all matters pertaining to the State Bar. Unless expressly authorized by the board or the rules of the State Bar, a committee member must not act or speak or purport to act or speak for the State Bar or for any State Bar committee, make any public communication on behalf of the State Bar, or pull or put to the vote of all or a substantial number of licensees any matter on which the State Bar has acted or is empowered to act. I think that this rule is really important in this age of sort of instantaneous communication. One issue with speaking publicly, like whether it be via social media or otherwise, is that it's not always clear when a member of the Committee of Bar Examiners is speaking on behalf of themselves as just like an interested citizen or a member of the public, or on behalf of the committee. And certainly we don't want people representing that they're speaking on behalf of the committee, not to stakeholders or applicants in communications with those people. And you know, it's very important because, especially, you know, with the potential for misinformation and also the potential to sort of contradict positions taken by the body as a whole, this is a very important restriction to abide. Okay, you're done with me for now. On to Amy and Lisa, actually.
Thank you, Caroline. And Lisa,
Amy, when were we supposed to? I can't find my raise hand function.
you can't.
But I'm also using like an outdated version of Zoom.
Okay. Well, yeah. Do you have a question?
I recognize your raised hand in the form of a raised voice, Kareem.
Thank you. I appreciate that. Good morning, and thank you everyone for your presentations. I just have a question about inquiries we received from the public and how that should be facilitated from our role as a CBE member, then our role as a public member of California.
So if you receive communication from a member of the public directly, as opposed to through the channels that we, you know, post on the agenda, for example, sending public comments to Kim or communications that are coming into, you know, the admissions email line and everything, what I would recommend is you forward them on for distribution to the entire committee for consideration if you think that, you know, the committee would benefit from hearing the person who's contacted you's perspective. The other thing is it's perfectly acceptable to ask members of the public to contact you through the appropriate official channels because, you know, we recognize that there are a lot of there are a lot of applicants every year, a lot of law graduates, a lot of stakeholders in the state bar, and public and members of the CBE don't always want to be fielding communications related to committee business in their personal email inboxes. So, you know, I think you have two options really: forward it along for distribution as public comment, or, you know, ask the person respectfully, like, you know, please communicate with me through these official channels that exist, and we'll make sure that your concerns are shared with the entire committee that way. You know, and so that's another way to go about it. Does that answer your question?
It does. I think one of the, well, because let's see, I think I'm almost 2 years in to the committee. And so I think there's another thing that I learned in this year's term, that there's much more interaction you could have with staff, but I guess that's not discussed in that element. So are you able to expand off what that is, or how that impacts CBE members?
Oh, in terms of members interacting with staff directly?
Correct.
Yeah, so members can interact with, members are allowed to reach out to staff. There's no, you know, Bagley-Keene issue or anything. Staff is there to facilitate, you know, and obviously has its own roles to play in various decision-making, but you can always reach out to a member of the staff, and that can, you know, include, I mean, for purposes of keeping things organized and making sure that communications are being routed to the right place, you may want to funnel communications through Amy, or depending on what it is about, like if it's about the agenda, maybe through Kim. But, you know, trying to target the communication to the right person, I think, is good. And then the other thing, of course, is avoiding serial communications. So there's no problem with communicating directly with staff, but you don't want to get into like a daisy chain email communication that involves staff plus other members that could be distributed then to other members, and then kind of begin this whole, you know, off book like communication, which we want to avoid completely.
Understood. And then the other thing was that you could reach out to legal counsel as well.
Yes, and yeah, and you guys, I think, you know, I communicate with several of you over email when legal questions come up, Bagley-Keene questions come up, and I'm always happy to answer questions. So you guys can also feel free to email me. And if I'm not the right person to answer the question, or it's something that has to do more with programs, then I can always pass the communication along. So that's always an option.
Thank you.
Yeah, thank you, Kareem.
Any other questions? Okay, so with that then, thank you, Caroline, and we'll hear from you shortly. And next we have Lisa, who's going to be covering exam development as well as grading. And unfortunately, Christina Dole is really busy with the grading unit, as you can imagine. So she's not going to be able to join us, and Lisa will be covering her slides and her part of the presentation.
Thank you, Amy. Good morning, everyone. Kim, is there a slide before this? Oh, Ashley, there's slides. Yeah, okay. So there should be a slide before, yeah. So, okay, so the California Bar Examination is a 2-day examination. We used to have a 3-day, I believe in July 2017. It went from a 3-day to a 2-day. So the normal administration of the exam, on the first day, you would have, we administer 5 one-hour essay questions together with 1 90-minute performance test. And also on the second day, there is the MBE, the multi-state bar examination, which is, the California itself develops the written portion of the exam, but we do use the National Conference of Bar Examiners developed examination. That's the multiple choice portion. So, but for the October administration of the this just immediately passed October examination, we did have change up the format a little bit to accommodate the online remote administered exam. And so what we did is we have administered the 5 one-hour essay questions on day 1. But the performance test was administered on day 2 after the morning session, which was the 100 multiple choice questions instead of the normal 200 multiple choice questions broken up into 250 question parts. Next slide, please. Next slide. Yeah, thanks. So the scope of the subjects tested on the California bar examination, there are 13 subjects: business associations, civil procedure, community property, constitutional law, contracts, civil criminal procedure, criminal law and procedure, evidence, professional responsibility, real property, remedies, torts, trusts, and wills and succession. I do note here with the asterisk that both subjects of civil procedure and evidence do test, in addition to the federal rules, they test the California rules and code. And then with regard to professional responsibility, it tests both the ABA and the California rules. Next slide. Okay, so did we skip something? Yeah. So the California bar examination essay questions and performance tests, this is kind of the general outline of how the questions are developed. The essay questions we do solicit from professors and other qualified drafters throughout the country. And the performance test is drafted by a team, specific team that we have here in California. And so then after the questions and the performance test are drafted, they go through a process of editing, initial editing. And then after that, the questions are pre-tested. They are pre-tested by established bar exam graders. And through that pre-testing, we ask for the graders' opinions and expertise as to whether or not there might be any biases that might be in the question, for example, or if the question might be too long, too short, the adequacy of the calls of the question, any ambiguities, things like that. So after we receive the feedback from the pre-testing, the questions go through a further editing process that is informed by the pre-testing, and then the questions as well as the performance test are banked. And the bank is from where we can draw each question at the time that we develop the actual exam for each examination administration. So it's possible that we have, any administration can choose from a recently developed question or, a question that was developed in the past. Next. Okay, so in addition to the California bar exam, we have the first year law students examination. And it's affectionately called the baby bar, and that is for applicants who go to registered law schools and other special students. So and that is a one-day examination. In the morning, we administer 4 one-hour essay questions, and then in the afternoon, we were missing something, but anyway, in the afternoon, yes, there's a 100 multiple choice item exam that it's developed in California itself. So we don't go to the national conference for that particular part of the baby bar. So the scope of the first year law students examination is limited. It's only basically the 3 subjects that applicants learn in the first year of law school. So that's contracts, criminal law, and torts. Next slide. And the development of the first year examination. Okay, slide, yeah, sorry. The slide before. Okay, so it's essentially the same as how we develop the essay questions for the bar exam, except that there is no pre-testing. We don't do any pre-testing on the first year questions. Okay. Okay. So with respect to the grading of the bar examination, first and foremost, there is the anonymity of the applicants. So nothing about the applicants, no personal information, no names, anything with respect to the applicants is known to the individual graders when they grade the exam. So there is the logistics, with respect to logistics of the exam grading. We do have a return of the materials from all of the test centers throughout the state of California. And then we also download all of the information, the exam answers from ExamSoft. And then there's the assembly of the answers in preparation for the grading by the graders. The graders are all active California attorneys. There are 6 separate grading groups of 16 graders, up to 16 graders each. And that includes the, I think that does not include the apprentice graders. So in those groups of graders, we also have apprentice graders every exam. And those apprentice graders are generally graders who are learning. They don't actually grade the exams. So the separate grading groups, the 6 groups, correspond to the 6 written questions that we have, the 5 essay questions and the 1 PT. Each of these grading groups is supervised by a member of the examination development and grading team, which we call the EDGE team. And these separate grading groups only grade 1 question per exam. So, you know, they don't grade like multiple questions. They're all dedicated to 1 question. Each grader is required to do pre-grading research, and that is individual research on their own, thoroughly researching the question and formulating an answer. And that is part of the preparation for grading. We do have 3 calibration meetings, and in conjunction generally with the 2nd calibration meeting, we invite law school observers, which generally include law school deans and other designated law school personnel. So with regard to our grading, just recently, we used to have 3 phases of grading, but the committee authorized now, I believe it was in August of this year, we went to 2 phases of grading. That is only the first read and the second read. In addition, what's changed is that the California Supreme Court has reduced the total scaled score required to pass the examination from 1440 to now 1390. In order to pass on first read, the applicant needs to attain a 1390 scaled score. We scale to the exam to the multiple choice part of the exam. And then in order to get to second read, the applicant would have to score between 1350 and 1389.99, so basically under the 1390 passing. And then for the first year exam, there are 4 grading groups of 3 graders each, and that again corresponds to each one of the 4 written questions. And the entire grading group is led by 1 EDGE team member. There are 2 phases of grading in the first year exam. There's a first read and what we call reappraisal. So in order to pass on the first read, you'd have to score a 560. And in order to be reappraised, automatic reappraisal, if you score between 540 and 559.99, which is just under the 560. Next slide. So we have, you know, many people ask why it takes so long to grade the California bar examination. And these are some of the reasons. So there are a large number of applicants in California. I believe the only state that might beat us is New York. So in July, there are we test approximately 9,500 applicants. And in October of this past year, we did have more applicants than that. And then in February, there are less applicants, but approximately 5,500. This is just on average in February. Also, the volume of the answer files to download and assemble, there are 6 written questions. So you multiply that out by 9,500 applicants, and there are approximately 57,000 on average answers to grade in July for a July exam, and approximately 33,000 in February. And then also, in order to ensure calibration of graders, we need to limit the number of graders in each grading group. So because it is a lot harder to calibrate a larger number of people to make sure that they're all grading you know, on the same page. And it shouldn't make any difference whether you get one grader or another, because they should all be grading the same. And of course, there are 2 phases of grading that also extends the time that it takes to grade the exam. So this is Caroline's. Caroline?
Yes, thank you. Okay, so this is intended to be a brief overview of testing accommodation law as it stands in California. And the State Bar, as a public entity, is subject to Title II of the ADA. Private entities are subject to Title III. But in this presentation, at the request of certain members, asking for sort of more guidance on documentation and other aspects of evaluating testing accommodation requests, I've included some guidance from Title III, which, as I said, applies to private entities, but it can be very helpful for us to look towards that to determine, you know, how to evaluate our testing accommodation petitions, which, you know, we're really evaluating under Title II, but there just is kind of a dearth of available guidance and regulations on Title II testing accommodation issues, unfortunately. So under Title II of the ADA, which the State Bar is bound by, a public entity may not administer a licensing or certification program in a manner that subjects qualified individuals with disabilities to discrimination on the basis of that disability, nor may a public entity establish requirements for the programs or activities of licensees or certified entities that subject qualified individuals with disabilities to discrimination on the basis of disability. So this regulation is considered to capture the State Bar's requirement to reasonably accommodate applicants that have medically driven needs for certain testing accommodations. What constitutes a disability under Title II of the ADA? The term disability is really a term of art. It means a physical or mental impairment that substantially limits one or more major life activities, a record of having such an impairment, or being regarded as having such an impairment. Oh, you know, I think hold on one second. I just have to plug in my laptop here. Running low. Okay, all right. Okay, the term disability is interpreted in favor of broad coverage. So rarely are we ever engaging at the committee level in conversations about whether a person is or isn't disabled. I mean, typically by the time we're reviewing a testing accommodation petition, that isn't really the issue. The issue is what's the appropriate accommodation for that person based on their own specific limitations. Substantially limits is also a term of art. It is construed broadly in favor of expansive coverage, and and whether or not a person's disability substantially limits one or more major life activities, that determination must be made without regard to ameliorative effects of mitigating measures, such as medication or hearing aids. And this question has come up. So whether this is just in the context of determining whether or not somebody is disabled under Title II of the ADA, as opposed to determining what are the appropriate testing accommodations once we've reached the determination that they are disabled. Major life activity includes self-care, performing manual tasks, seeing, hearing, eating, sleeping, for our purposes, testing, working, and it also includes major bodily functions. So all the things that you would probably think of when you think of major life activities. As I mentioned, I did include some slides on Title III just for our additional guidance, because there are more robust regulations with respect to testing accommodations that apply to private entities, such as the NCBE or other, other private entities that are administering tests like the bar exam does, and looking to those regulations can sort of help provide some interpretive guidance for what is also required under Title II. But just making clear, you know, the next few slides are coming from Title III. Title III applies to private or public, so it's just meant for additional guidance. An entity offering an examination, oh, sorry, if you don't mind going back. Thank you. An entity offering an examination covered by Title III, which would be mainly private entities such as the NCBE, must assure that an examination is selected and administered so as to best ensure that when the examination is administered to an individual with a disability, the results accurately reflect the individual's aptitude or achievement rather than the disability or the impairments associated with the disability. Under Title III, there are some helpful regulations about what constitutes reasonable documentation of a person's disability and also their medically driven functional limitations, which are really what we care about, as opposed to really, so, you know, we get various information when we're evaluating testing accommodation requests. It might include a diagnosis, but what we really are looking for is what are the person's medically driven functional limitations? What are the results of the person having the disability? Because there are plenty of people that have disabilities that don't have any functional limitations with respect to testing or other, you know, but they may with respect to another major life activity. So it's a very case-by-case review, but in Title III, we do get some good guidance on what reasonable documentation of those medically driven functional limitations might be. Any documentation required by a testing entity in support of a request for testing accommodations must be reasonable and limited to the need for the requested testing accommodations. Requests for supporting documentation should be narrowly tailored to the information needed to determine the nature of the candidate's disability and his or her need for the requested testing accommodations. Requests for past accommodations provided in similar test settings and those provided by the applicant's public or private school should be given considerable weight and should generally be granted without the need for further documentation. Under Title III, reports from qualified professionals who have evaluated the candidate should take precedence over reports from testing entity reviewers who have never conducted the requisite assessment of the candidate for diagnosis and treatment. This is especially important for individuals with learning disabilities because face-to-face interaction is a critical component of an accurate evaluation, diagnosis, and determination of appropriate testing accommodations. Required modifications to an examination may include changes in the length of time permitted for completion of the exam, adaptation of the manner in which the exam is given or the format in which it's given, and appropriate auxiliary aids, unless doing so would fundamentally alter the measurement of the skills or knowledge the examination is intended to test or would result in an undue burden. So, you know, one example of the fundamental alteration of the measurement of the skills or knowledge might be somebody asking to have an open book exam on the bar. Obviously, you know, that we're testing people's skills and knowledge in a closed book environment. An open book assessment is not going to give us the information that we need. So the next few slides are just an overview of some, you know, pretty milestone cases in this area, and you're all mostly familiar with them already, so I don't want to spend too much time going through, but these cases are good. They provide good, helpful guidance. They sort of are the goalposts for testing accommodations, and then also I'll talk a little bit about the DFVH consent decree, which isn't binding on the state bar, but again, provides some helpful guidance. So in the NYARP versus NCBE case, an applicant with blindness was granted a preliminary injunction to use JAWS screen reader software and Zoom text on the MBE portion of the bar exam. And the NCBE argued that the ADA only requires them to provide reasonable accommodations and that they're offered accommodations of a live reader, audio CD of the test questions, Braille version of the test, and or CCTC with a hard copy version in large font were reasonable. The Ninth Circuit deferred to the DOJ's interpretation of the ADA and held that the best ensure standard means test entities must administer the exam to best ensure that it accurately reflects aptitude rather than disabilities. And because the live reader and other accommodations NCBE was prepared to offer would not allow the applicant to take the exam without severe discomfort and disadvantage, the applicant had demonstrated that the test was not accessible to her and that the accommodations offered were not reasonable. I like this quote from Enyart because I think it's something that we all need to keep in mind. Assistive technology is not frozen in time. As technology advances, testing accommodations should advance as well. And so, you know, what may have worked for applicants 5 to 10 years ago isn't necessarily the standard for accommodations today. And we need to be keeping up to date on, you know, these types of new developments that may better suit the best ensure standard. In Elder versus NCBE, a case that's sort of similar to Enyart, an applicant with blindness who passed the Maryland bar exam with a live reader filed for an injunction for the use of JAWS on the California bar exam. Relying on Enyart, the United States District Court for the Northern District held that JAWS would best ensure that Elder's performance on the California bar exam would accurately reflect his abilities rather than his visual impairment. Okay, so I mentioned I would say a little bit about the consent decree. A few years back in 2012, DFEH sued LSAC, which is the entity that administers the LSAT, also a private entity like NCBE, alleging that their process for considering testing accommodation requests violated the ADA by imposing onerous documentation requirements, denying requests for reasonable accommodations, and providing different and less desirable score reports to test takers who received additional test time. The DOJ intervened in the lawsuit, and that expanded the case into a national class action suit. In 2014, LSAC entered into a consent decree, which was essentially a settlement between the parties here, requiring it to pay $8.73 million and to adopt reforms to end its practice of flagging LSAT scores, streamline its review of accommodation requests by automatically granting accommodations previously received for a standardized exam, and to implement additional best practices as recommended by a panel of experts. LSAC filed an appeal, but the court's 2015 order upheld, LSAC filed an appeal against most of the best practices panel report, and the court upheld the report. In March 2018, the court granted a DFEH motion for contempt, finding that LSAC had responded to accommodation requests with what they called 50% emails or partial grants in violation of the consent decree requirement that they automatically grant previously approved accommodations, and failed to keep accurate internal records regarding whether requests were granted in full or denied, and failed to provide DFEH with reasonable access to those records. The order extended the nationwide settlement set to expire on May 29th, 2019 to May 29th, 2020. I was doing a little bit of research before the presentation today to see if it got further extended, and I couldn't find anything. So I'm left assuming that the order has now expired, but I would assume that LSAC will continue the practices set up lest it be sued again and go through the same process. Bibber versus National Board of Osteopathic Medical Examiners. Bibber requested extra testing time for a licensing examination. Bibber had a history of receiving accommodations from high school to medical school. However, he took the GRE and MCAT without accommodations and received average scores on those exams. Whether an impairment substantially limits performance in a major life activity must compare the individual's abilities to those of most people in the general population, not to their academic peer group or to other test takers who are not representative of the general population. And I think, you know, this comes up a lot for us in that, you know, academic achievement is a relevant factor in sort of looking at whether a person has really had a demonstrated medically driven need for accommodations, because those are necessary in order for them to just have equal footing. Accommodations are not meant to put people at a, advantage as compared to their peers. The court found that Bibber's dyslexia did not substantially limit her ability, her ability to read or process information as compared to the general population. Thus, she was not considered to be disabled under the ADA because she wasn't substantially limited in one or more major life activities. In Black versus National Board of Medical Examiners, the court held that a medical student with ADHD was not entitled to additional time to take a board examination. ADHD did not substantially limit the student's ability to learn, to read, to remember, or to concentrate in comparison to the average person. Black's record consistently revealed average or above average performance without the accommodation of extra time. To qualify for an accommodation, a person must demonstrate that a disorder substantially limits her in comparison to most people in the general population. Okay, so a basic timeline for testing accommodation for the California bar examination. And I mean, if Lisa has anything to add after I just give my 30-second spiel on this, please feel free, Lisa. But so an applicant files a petition for testing accommodations. Applicants are encouraged to file as soon as possible, as soon as they know that they need a testing accommodation, because there is some processing time involved, and they make their request. They support their request with forms and a narrative that explains their need for testing accommodation. And then the state bar staff will review the documentation submitted, determine whether we need additional documentation to evaluate the request, and get that additional documentation if needed. Then a decision is made to either grant, deny, or partially grant or partially deny the request for testing accommodations. And the applicant then has the opportunity to appeal that determination. And if they submit additional documentation with their appeal that convinces staff that, one or more of the denied accommodations is warranted, then staff can just go ahead and grant, that without the need to go back to the committee. If staff feels that it's proper to continue to deny, then it goes to the committee for a second bite at the apple, basically. And the applicant may receive a granted accommodation on appeal that they didn't get in the initial decision. And there's just some examples down there of the typical accommodations that we see here at the state bar: extra time, private or semi-private room, permission to dictate, special versions of the exam questions, those types of things. So thank you.
Carolyn?
Yes.
Oh, is the applicant's appeal a de novo appeal?
The applicant's appeal to the CBE on a denied accommodation is yes, the CBE just reviews it as if they review the full universe of information supplied by the applicant, and they can make a decision whether to deny or grant based on, all of the available information. So yes, there's no like abuse of discretion standard or anything like that.
Thank you.
Mm-hmm. So that's it for me. Thank you.
Thank you, Caroline.
Mm-hmm.
Next, we have Tammy, who will be covering eligibility and exam administration. Tammy. Oh, Tammy, you're on mute.
I got it. Good morning, everyone. Operations and management, in essence, is over the complete aspect of everybody who is applying to sit for the exam, making sure that they're eligible, making sure that the exam itself is administrated the correct way and that everything that we need is available for the exam. So some of the main areas of responsibility are the eligibility section, which includes applicants who are registering with us for the first time so that they can take a future exam with us. It includes the exam applications for the first year law students exam, as well as applicants who apply for law office study. We also have other areas of eligibility that include special admissions, which is for applicants who apply as a foreign legal consultant, registered in-house counsel, registered legal aid attorney, military spouse attorneys, pro hoc vice, practical training of law students, and out-of-state attorney arbitration counsel. Some of the legal education qualifications include a JD degree from an ABA approved or California accredited law school, or you would have 4 years of law study from a recognized unaccredited law school, law office study, or distant learning program. We also have foreign educated students who possess a first degree in law, and attorneys who are admitted in any other state or country with proper documentation to confirm their admission to their jurisdiction. Another area of the operations and management unit is examination administration, which is where we process all fees that are collected. We secure contracts for all test facilities. We order all of the exams, including the multi-state bar exam or MBE from the National Conference of Bar Examiners. We prepare all of the exam materials and supplies that go out to the test centers. We coordinate all of the events set up for each test center so that staff has everything they need in order to conduct the exam efficiently. Shipment of all exams and supplies to test centers, proctor training, as well as we cover all of the mail that comes in through admissions through our own separate mail room outside of the rest of the state bar. We have various sites that we administer the exam across the state of California, covering both Southern and Northern California. The red arrows will show you where our standard test sites where we have multiple people in the room. And then the purple arrows will show the areas of where we have testing accommodations. And for the February 19 bar exam, we had 6,080 applicants that applied for the exam, with 449 applicants that were granted testing accommodations. And for the July 2019 exam, we had 9,469 applicants who applied for the bar exam, with 637 applicants who were granted testing accommodations. For the bar exam administration, the examinations are taken on a laptop or written by hand. Security is, of course, the utmost importance. This includes the test center as a whole, as well as the security of the exams themselves. Items allowed at the test center are different during the MBE session compared to the California portion of the exam. During an exam, if there is a conduct violation that an applicant has, that staff have seen an applicant has done, a Chapter 6 notice of violation will be issued. A Chapter 6 of the admission rules pertains to the conduct of applicants at the examination. Applicants are expected to conduct themselves professionally at all times at an examination test center. Conduct that violates the security or administration of an examination may be reported to the State Bar as a Chapter 6 notice of violation of examination rules or policies. In extreme cases, it may require dismissal from the examination test center. Some of the common Chapter 6 violations include possession of a cell phone or any other electronic or digital device in the exam room, submitting examination answers that do not comply with examination instructions and rules, observed writing, typing, erasing, or marking after the instruction to stop writing and typing is announced, as well as other various reasons, including cheat sheets, notes, petitioning for religious headwear after the final filing deadline, and among other things that we encounter during any administration. There should be one more there, Kim, that shows the, oh, back one. There we go. So for applicants who are issued a Chapter 6 notice and receive a sanction from that Chapter 6 notice, if it is a disputable violation, there will be the first process of staff making a determination on whether or not the sanction should be imposed. After that, applicants are allowed to request a special hearing that is conducted by our staff. Once that determination from the hearing has been made, the applicants do have the ability to take their appeal to the CBE and have the committee hear the appeal. And once the Committee of Bar Examiners has made their determination on that appeal, the only last step there at that point would be for them to take it to the California Supreme Court. And that, in essence, is operations and management.
Good morning. So again, my name is Tara Clark and I'm the program manager for moral character determinations. I'll be going through our slides, and I've asked our attorney, David Lane, just to jump in as he sees fit to add any additional context. So Next slide, please. This is just a brief overview of the unit. So when we are in the office, and I'll talk about this more in a moment, we do have our group in Los Angeles where the process starts. And if a file cannot be cleared by them, it does come up to the investigators, the supervisor, David and myself, and moral character. And then if an applicant is denied and they do appeal, it would go to the Committee of Bar Examiners first. So this is just a brief overview. Next slide. Thank you. So positive moral character determination is one of the requirements for admission to practice law in California. It's required by Business and Professions Code 6060 and defined by the admission rules. So good moral character includes, but is not limited to, qualities of honesty, fairness, candor, trustworthiness, observance of fiduciary responsibility, respect for and obedience to the law, and respect for the rights of others in the judicial process. So you will see this come up again later in our presentation. We had a moral character working group who actually went through and looked at the moral character process last year. We had 3 of our committee members who were on that, Mr. James F. Dean, Larry Kaplan, and Judge Tori Alba, as well as 3 law school deans or their representatives and the director for the Stanford Criminal Justice Center. So they went through and looked at the process for us to help ensure that it is transparent and it is consistent with the societal expectations for rehabilitation. So you will see these come up again later. Let's see. And next slide, please. Yep. Thank you. And so we do encourage law students to always submit their moral character applications as soon as possible, no later than their 3rd year of law school. The reason being is that it can take 6 months or more to complete this application. It is essentially a background check, and it does require a lot of information from them. So they have to give us their education history, their residence history for the past 8 years, any self-employment or employment since they were 18 years old that was law related, or if it lasted more than 6 months, as well as the other information you see here. We also do encourage students to always gather the information early. For example, for someone that has a criminal conviction, we have the forms available online so they can see specifically what it is we're looking for, such as the arrest report, the docket, and the conviction. Okay, thank you. And so this is the overview of the department again, as I mentioned. So with the AIMS, the Admissions Information Processing Center, all of the applications are submitted online. Once they are submitted, our pre-processing unit goes through and looks for the initial completion. So for example, they are required to provide their mother's maiden name versus the married name. That is one error we see a lot, as well as applicants do not always include their driving record from another jurisdiction. So once they go, pre-processing goes through and ensures that the application is complete, the application will be considered filed. If there's no or minimal information, no notable or minimal information, it can be cleared at the pre-processing level. However, if there's anything that needs to be looked into further, it does come up to one of our investigators in San Francisco. From there, the investigators have acts of misconduct and whatnot that's within their purview to clear. We'll talk about that more in a moment. If they can't clear it at their level, then it will be referred to either the program supervisor, and again, they have the option to ask for more information, to clear it, or to refer it to myself. And if it can't be cleared at the staff level, then the applicant may be invited to an informal conference. So before the coronavirus pandemic, we were holding the informal conferences in person, either in the San Francisco or Los Angeles offices. They are scheduled for 45 minutes each, and it is something optional, but we do always encourage applicants to attend them if they're invited. The reason being is that it can be helpful to discuss the matter with them in person, as sometimes more information comes out or it can fill in gaps for us. Okay. Next slide, please. Thank you. And so this is just a brief example and overview of how the levels are cleared in our unit. So level 1 and 2 can be cleared by an investigator. So those are very minor things, and we make note of everything in a file. So it's not that something is necessarily a red flag if it is on this list, it's just that we do notate everything. So for example, we get the California driving record directly from the DMV. If there is a vehicle code infraction, we make a note of it. It's something minor. We typically don't need to ask any follow-up questions unless for some reason there's a failure to appear related. And if somebody's availed themselves of their right under the bankruptcy code, that's perfectly fine as well. We're just looking to make sure there is no objection, no allegations of fraud and whatnot. And as you can see, the level of severity of the items that we are documenting does progress. So once you get to a level 3, that's where the program supervisor does need to get involved. And a serious level 3 or level 4 is where the program manager would then get involved as well. And so the next slide. And so this, again, gives the overview of how we break up the information. So it does siphon out. So the investigators deal with more files, and then only the more serious files come to the program supervisor, myself, and then finally an informal conference. So it is a very small number of applicants that actually come to an informal conference, and an even smaller amount that get denied each year. Okay. Thank you. And so in the beginning, we did talk about the moral character working group. So one thing that they did is we went through and looked at the materials that were available on the website and wanted to ensure that applicants, law schools, everyone involved is able to fully understand the process, so create more transparency. And so there are several new documents online. One of them is the factors and conduct relevant to a moral character determination. And as I mentioned previously, we're seeing here again, candor and honesty are two of the main factors. We also do look at the severity of the issue, the length of time since it occurred, the frequency, and the rehabilitation. And on the conduct, when we looked through the other jurisdictions, some of them, not all, had brief descriptions of what kind of conduct or misconduct we may be looking for. So if you go onto our website now, you can see that we do have a paragraph on each item. So that way, it hopefully clarifies what it is that we're looking for both applicants, law schools, and everybody involved. And so the headings here come directly from the definition of good moral character again. So the moral character determination guidelines, for those who were on the committee last year, referred to it as a matrix initially, but once we had a graphic designer get involved, it's essentially more of a PDF booklet now. And you'll see that under each heading, and we have the others on another slide, so respect for and obedience to the law, honesty, fairness, candor, and trustworthiness, you have the related conduct or misconduct that we're looking for, and it just spells out more clearly for the applicant what they may. That was mine, there's somebody else's, but okay, next slide. Thank you. So again, so here we have the other two. So we have the other two traits. And again, you can see we have the factors listed underneath. For example, under respect for the rights of others in the judicial process, currently our moral character application does not ask any questions related to the unauthorized practice of law, but it is something that we look for both attorneys who are out of state and sometimes law students who are potentially overzealous. But so these guidelines help to create a more clear path for the applicants and what they can expect. Let's see, next slide. And this is an example of one of the pages from that booklet. So as you can see, it's broken down into additional inquiry seldom needed, additional inquiry may be needed, and informal conference may be needed. So all of this is predicated first that the applicant has provided us with enough information up front. For example, again, going back to the criminal, we have our Form 2, which asks for a narrative leading up to and through the arrest. Sometimes we get just a very brief statement that says arrested for a DUI. So even there, if it was something that was some time ago, the blood alcohol content was low, we may still ask for more information just to get the full picture and ensure that our file is properly documented. However, as you can see, for an honor code violation, something where they were dismissed just to a low GPA, we likely don't need any additional information. We may ask for additional information if it's a minor violation as defined by the school, and an informal conference may be needed if it's a serious violation as defined by the school. And for these, since we did have the law school deans on the moral character working group, each school seems to handle each type of infraction differently, which is why we were crediting how the school actually counts it in self, rather than just having specifically listed plagiarism, something or some other type of misconduct, as you might see in others. And at the bottom of each screen, you will see the mitigating, aggravating, and rehabilitative factors that we do take into account. And as previously mentioned in the factors, you will see again that the length of time since the incident, the severity, and the frequency of the acts are all again given significant consideration. Next slide. Thank you. So after an informal conference, there are several options that staff have. And I believe everybody currently on here right now was here before, but so it was October last year when informal conferences switched to staff. Prior to that, the committee members would form the panel. So as of October last year, the informal conference panel consists of myself, our attorney, David Lane, and one of the two program supervisors typically. And then from there, applicants now have another essentially appeal path, and we'll talk about that more in a moment. But So if someone who's granted a positive determination, that is valid for 36 months or 3 years. However, if they're not admitted to practice before then, for example, maybe they're not able to pass the bar exam, they can submit an extension application before that 36-month period has expired. The extension application, it's about half the cost and it's less intensive. They're only giving us updated information since the last application, and they're able to answer no or nothing new to report if that's applicable.
And can I just jump in really quickly to say that, you know, since we've been conducting the informal conferences via Zoom, they've been going pretty well. We've become experts at dealing with Zoom glitches. Yeah, I just wanted to note that.
Yes. Yeah, things have changed a little bit, I think, in all facets of our work. So that's definitely one of them. And so another option that staff has after the informal conference is sometimes new information comes up. During the informal, so we may ask for additional information, or we may ask for the Office of Chief Trial Counsel to review the file and give their opinion. The reason being is that if an applicant is denied and they go through the committee for the appeal, the denial is upheld, and then the applicant appeals to State Bar Court, the Office of Chief Trial Counsel will actually defend the committee's position there. So it can be that we ask them for their expert opinion since they have a slew of attorneys at their disposal. And another option that's not always well known is abeyance. So rather than just a straight positive or a negative determination, we may ask the applicant to complete some act prior to being admitted. So for example, someone who may have a history of substance abuse, we may ask them to participate in the Lawyer's Assistance Program, and they help both attorneys and applicants with those sort of issues. A typical abeyance is that if the applicant successfully completes the terms prescribed, that it's administratively cleared by staff, or in the rare occasion where they are asked back for another informal afterwards, and that would be conducted as soon as possible. However, if the applicant does fail to complete the terms of the abeyance, then that is considered and it's gone back to staff. And lastly, we also do have, we do have the option for a denial. A standard denial is for 2 years. However, if someone is essentially on the right track for rehabilitation-wise, then they may get a 1-year denial. And an applicant, and this is the new step that occurred last year once the informal conferences switched over to staff, if they are denied a positive determination by staff, they may request an administrative review by the Committee of Bar Examiners. How that works is that the subcommittee chair for moral character will designate 2 panel members to conduct the review, one who must be a licensee of the State Bar, and that'll be conducted within 60 days of that request. They will review the record, and then they will make their recommendation to the full committee. So we'll be seeing that later today in closed. And then the committee will either affirm or change that determination, and the committee has the full options available to them. So everything on this slide is at their disposal as well. If the applicant is still denied a positive determination by the committee, that's where the applicant may appeal the decision to State Bar Court. And the State Bar Court has 2 departments, the hearing department, which is the first level, and then the party that does not prevail may appeal to the review department. And again, the party that does not prevail may appeal to the California Supreme Court. And next slide. And I think you'll have to press it a couple times. Oop, okay, didn't work, that's okay. I think, and then the only other thing I think that David likes to add typically is that so a moral character case could potentially be appealed up to the U.S. Supreme Court if there are constitutional issues involved. I think that hasn't happened in quite some time, but that would be the very tip of the arrow. And so we just highlight the committee administrative review since that is the new step last year. And so again, so if you haven't had the opportunity to look at the new moral character documents, I would encourage you to do so. So they were published on our website last year, or I'm sorry, this year, at the end of July. And so you're welcome to go ahead and take a look. And like I said, that one section that we looked at for the honor code violations, that's part of the guidelines.
Can I just echo that? The moral character working group that you know, I assisted with, along with a bunch of other staff, produce these virtual documents that are really impressive and add a ton of information for the public to the website, and the available information, increased transparency, et cetera. So I really encourage everybody to check the stuff out. The group did a great job. Thanks.
Thank you. And that's all we have.
Before we get into the next portion, can we take a 10-minute break? It's 10:37 right now, and if everyone can just come back at 10:47, and we'll resume our orientation.
Okay. Thank you.
Thank you.
So it's now 10:47, and are we ready to resume?
I believe so. I think Natalie.
Yes. Natalie's here.
Great. Your next presenter, Natalie.
Okay, great.
Take it away.
Okay, welcome back everyone. So I'm Natalie Leonard, Principal Program Analyst working with Law School Regulation, and we'll be talking a little bit about the unique law opportunities to attend law school in California. The first one is that in California, we have not only schools that are approved by the ABA, but also schools that are registered or accredited. And they each offer different opportunities for students that are confident that the place that they want to practice law is California. As a result, there are many more opportunities for students at many more points in their lives in California than other states. Next slide, please. Thank you. So there are 18 ABA approved schools. Those are approved and regulated by the Council of the Section of Legal Education and Admissions to the Bar at the ABA in Chicago. They are fully regulated by that body, and those students are eligible from an education standpoint to take the bar in California. And then we have 16 registered schools. That's usually the first step when a school opens in California if it's not ABA approved. Because those schools are new or don't meet the specific, more stringent standards of the accredited process, those students must pass the first year law students exam in order to go beyond their first year and claim credit for study beyond their first year. So that exam is a consumer protection measure to help the students understand if they are progressing appropriately to be able to be ready to be licensed at the end of their study. The second type of schools, usually a second step, is a California accredited school. Those schools have more stringent standards, and they're also held to a minimum 5-year pass rate of 40% or more. And very soon there may be a jointly accredited status for those accredited schools that are also accredited by a regional or national accreditor. And we'll talk a little bit more about what that means during the Ed Standards section. The State Bar will accredit the program of law school. A national or regional accreditor will accredit the entire institution to make sure that there is a good organizational structure in place for the school. Next slide, please. In terms of requirements and the sorts of things that you will see here at the committee from the various schools, they are overseen through a number of elements. The first is a 5-year periodic inspection. The committee can order more frequent inspections if they are necessary, for example, if non-compliance is suspected. Each year, the schools file an annual report due on November 15th. The committee also has a role in making sure that proper disclosures are made to students and the public so that they understand the rights and limitations of attending a registered school versus an ABA approved school. And these schools are part-time programs only, and their calendars are governed by California Business and Professions Code 6060. And again, these are the students at these schools who must pass the first year law students examination. If they pass it within the first 3 administrations after they've become eligible, they can not only claim credit for their first year of study, but also any study they've completed after that. Some students will continue to study up to the time that they pass. Others will complete their first year and take time off to study and return to school once they pass the first year law students examination. Next slide, please. As for accredited schools, many of the requirements are similar, though they are tailored to the rules that accredited schools must follow. But instead of the first year law students examination, the school as a whole must maintain a minimum cumulative 5-year bar passage rate of 40% or more. And that percentage is calculated only amongst those students who decide to take the bar exam. Okay, next slide, please. The committee and the State Bar also conduct a number of different fora to engage with the law schools throughout the year, law schools of all types. One of these is the Law School Council. This is a 7-member body of ABA deans that may be the official law school dean or any other administrator. Usually meets twice per year and focuses on issues of concern to ABA law schools. They are next scheduled to meet on Wednesday, December 2nd. That is 2 days before the committee meeting, and that meeting will be broadcast on Zoom for anyone who's interested to watch. Another body meets more frequently. This is the Committee on State Bar Accredited and Registered Schools. This is composed of 5 deans, 3 from accredited law schools, 2 from registered or unaccredited law schools, and 2 CBE selections. The CS bars this year is scheduled to meet on the Wednesdays prior to the CBE from 1 o'clock to 3 o'clock. So the careful observer will note that the Law School Council and the CS bars will both meet on December 2nd, Law School Council in the morning and CS bars in the afternoon in December. The State Bar also publishes a quarterly Law School Deans e-newsletter that talks about the initiatives that have been going on that may be of interest to law school deans. This year, the communication has actually been much more frequent than the quarterly newsletter would suggest. Deans have been copied on all of the communications related to the online exams, and we've received very positive feedback for doing that this year during these extraordinary times. The 2 larger groups that we conduct are usually conducted in person. The Law School Assembly allows 2 representatives from each of the 3 types of law schools. The registrar's meeting is for registrars. The difference between the 2 is that Law School Assembly generally focuses on policy and research initiatives at the State Bar, as well as State Bar exams. While the registrar's meeting focuses on specific record-keeping, technical, and admissions type questions. This year, they will be held via Zoom, similarly on the same day, December 10, and people will be able to attend from any location remotely and safely. You might remember that in the past, these were held one north and one south, and that won't be necessary with the adoption of Zoom meetings. This year, later today, and in recent past meetings, you know that the State Bar has been talking about a new purpose for accreditation, really looking at the rules that have been in place for quite some time now, making sure that they incorporate best practices. So just as we think back to the quote from the testing accommodations presentation, as technology changes, so do accommodations. As technology changes, so does pedagogy change, and the way schools teach and the way the committee may want to regulate those schools evolves as well. The new rules will feature a jointly accredited status for the schools that are accredited not only by the State Bar, but also take the extra step and create the extra protective infrastructure of a regional or a national accreditor. Next slide. Thank you. Does anyone have any questions? If there are no questions, I'll just take a moment to thank the committee members this year who have participated in inspections and who were adventurous enough to help the State Bar move to very safe yet very thorough remote inspections that have received positive feedback from the schools as well as the inspection teams. Thank you.
Thanks, Adam. All right, so if we don't have any other questions, if there are no questions, then we could move to the next agenda item, and I'll give this back to Esther.
Okay, so now we'll have public comments, and as noted on the agenda for today's meeting, public comments during the meeting will be limited. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. Your written comments have been considered by the committee and will shape our discussions and deliberations here today. So we thank you for that. The coordinator will attempt to call members of the public in the order that they appear. Due to the number of people requesting to make comments, we ask that you limit your comments to, let me see, do we have anyone raising their hands yet?
Yes, we have Jackie Gardina.
Okay. So we'll limit the comments right now to 2 minutes. To facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers. At 2 minutes, we will turn your microphone off and call the next member of the public. And to allow the committee the time needed to deliberate on the important topics it will be discussing today, we will not be able to hear more than a maximum of 30 minutes of total public comments. For those of you who are participating via Zoom video, you should have a function for virtually raising your hand. It's a hand icon and it should appear at the bottom center of your screen. If you wish to make a public comment, please click on that and the State Bar staff will call you in the order that they identify your raised hand. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. Again, doing so will alert the coordinator that you would like to make a comment, and she will call on you and open your microphone so that you can address the committee. The coordinator will call members of the public in the order that they identify with their raised hands. And we will begin.
Jackie Gardina.
Thank you, Chair Lynn, and good morning, members of the committee. I want to comment on agenda item 4A, action on proposal for new rules. And Chair Lynn, I'm hoping that you'll indulge me just a little bit longer than 2 minutes, only because I want to make sure that I can publicly thank all the people that were involved in the creation of the new rules. I want to acknowledge the members of the CS BARS committee who spent over a year creating the new set of accreditation standards that you're going to look at today. Dean Greg Brandis, Dean Jay Frickberg, Dean Marty Pritikin, Dean Brian Pertel, Greg Murphy, and your own CBE member, Kareem Gangora. The committee faced a number of challenges during this process. As you all know, writing by committee is never easy. Writing by committee with the restrictions of Bagley-Keene is even more challenging. And writing by committee with the restrictions of Bagley-Keene in the midst of a pandemic that affected members both personally and professionally was incredibly challenging. Despite these challenges, all the committee members stayed focused on the ultimate goal: to create a set of accreditation standards that reflected best practices in accreditation, that aligned the rules with the State Bar's dual missions of public protection and access and inclusion, that simplified the regulatory structure, and that allowed room for the evolution of legal education. And I believe that the CS BAR's proposed rules met these goals. And I want to commend publicly all the committee members for their efforts. But I also want to thank the State Bar staff, especially Natalie Leonard, for their efforts during this process. I know that the State Bar was navigating a series of pandemic challenges as well, not the least of which was administering the first ever remote bar exam. And I want to extend a thanks to two CBE members, Paul Kramer and Michael Cow, for their time, energy, and attention to the new rules. Second, I'd want to discuss process. Perhaps because I've taught civil procedure for almost 2 decades, I'm someone who believes in the power and importance of process. And I want to speak with an eye towards the future. Even if the CBE votes today to recommend this rule package to the Board of Trustees, there's more work to be done. As Mr. Kramer suggested yesterday or Wednesday at our meeting, the CBE may craft new guidelines to accompany the new rules that would be ready by the time they go into effect. CBE has the ultimate authority over accredited and registered schools. Nonetheless, I believe that a transparent, inclusive process from start to finish results in a stronger final product that has broad support. Even if areas of disagreement cannot always be resolved, they can at least be understood and unintended consequences uncovered. I will submit the rest of this comment directly to the committee for your consideration for future processes. But what I want to end with is I encourage the State Bar staff and the CBE to stay engaged with CS BARs throughout the process. As I said at the start, an inclusive, transparent process from start to finish results in a stronger product with broad support. We all have the same goals: increasing access to the legal profession, creating an affordable legal education, and ensuring students graduate as skilled, competent, and ethical legal professionals. While we may not always agree how best to reach those goals, we should engage with each other thoroughly in the debate about them. Thank you for your time and attention and for all the work done in creating the new accreditation rules.
Thank you, Ms. Gardina. The next person is Susan Volpe.
Hello?
Hi.
Hi. I asked to speak because I am speaking to actually the issue that Carolyn Holmes covered, which I thank her for the review of Title II and Title III of the ADA, but most specifically to a situation that I experienced. I was in the end of my third year at Pacific Coast University, and in September, when it was time to register again, I didn't receive any materials, so I inquired, and then I got a meeting, and then I was told that they would not offer me registration for my last year, which was really just 2 classes, because they could not, they didn't have the resources to meet the obligation of my disability. I have a visual disability. I have several different distortions in my vision that is due to a disease known as Sjogren's disease. And they did have to test me separately. I didn't ask to be tested separately, but they insisted. And basically, they did it for all those years. Why did they stop in September was because the Committee for Accreditation of Schools pulled their accredited status, and they had to become registered. And I think they panicked, and they actually admitted to this to me during our meeting, and that meeting was taped. They basically want to be able to get their accredited status back, and they can't. I'm one of those people that might not pass the bar on my first try due to learning new technology. I wasn't born this way. I was a high school teacher first, and then I became a paralegal. And towards the beginning of my start of law school, I had problems with my disease. And then by the beginning of my second year, it progressed to the point where I had to get assistance and learn new technology so that I can participate. And during my third year, during my third year, my schedule was changed so that I had limited classes so that I could learn this technology while I was still attending school. And all of those things were put in place by the former dean of academics, who left after they lost their accreditation. So the gentleman who decided that, I was to go, he's no longer there because they let him go. But here I am with 1 year left, and I wrote to Natalie, and I wrote to Miss Gardina, Jackie Gardina, and they said that I was writing to the wrong people, that I had to come to the Committee of Bar Examiners. So then I wrote to someone else. I can't remember her name. She's on the screen though, I think. And she sent my letter on to them. And I do, within that, a very short period of time when I realized that this was happening, I was able to make other arrangements for myself. I was accepted into Trinity Law School. In the visiting law school program, I was going to take some of the classes with them that I couldn't take at PCU because I went on a limited schedule. And then I met an attorney that, because I am a paralegal, I work independently. And I met a new attorney that I started working with, and she was lovely. And she said, go on the law office study program and apply there, and I'll help you finish your hours.
Can you please wrap up your comments?
Okay. Okay, so this is my thing. My thing is, you have great things in place for when you do testing. But during the time when people are in school and they're learning and they're handicapped, and in my case, it's a visual handicap, there's nothing in place. The textbooks aren't accessible. The teachers that are teaching us don't know we're handicapped because they're not permitted to know. And it's an issue. And I think it's an issue that should be addressed because, you know, I'm older now and this is second career. So but for the people that are there now, it's 0.5% that are in the legal profession with disabilities.
Thank you for your comment, Ms. Volpe.
And that's it.
Thank you. That concludes our public comments for this morning, and we will move on to report from the director. Amy?
Sorry about that. Thank you. So on this, the first item under my time is the review of the December 4th and 5th schedule. I've submitted that. It was an attachment here, attachment 0103. And I just want to make everybody aware of the upcoming meetings are scheduled as 2-day meetings. Are there any questions about that?
Yes.
Okay.
Yeah, didn't we get an email saying that for some reason we're not doing the question, on the 5th? So that means there's no meeting on the 5th, right?
We are still scheduling the meetings as 2-day meetings. Because, as you can tell, this one was streamlined because we wanted to make room for the CBE orientation. But I think we're going to continue with the 2-day format. At this meeting, the question selection is not going to be scheduled in conjunction with that meeting. I think an email was sent out to find out people's availability at another time in December. We are going to continue with the 2-day format given the multitude and the volume of topics that we've been covering at these meetings. Okay. All right. So with that, then the next item that I'll cover is updates on Office of Admissions and State Bar activities. And the next is a Blue Ribbon Commission. I want to give everybody an update on the status of that commission. As you may recall, this is a commission that is a joint effort between the State Bar and the California Supreme Court. The commission is going to be charged with looking at the practice analysis, the California practice analysis, the report and its recommendations, looking also at the National Conference of Bar Examiners 2020 job analysis, assessing whether the UBE would be appropriate for California, and if the UBE is not developing recommendations for adoption that examine the California bar exam. Looking at alternative methods for in the current exam, all in an effort to ensure that minimum competence in subject areas or skills are accomplished. So this commission will consist of 16 members appointed by the California Supreme Court. I mentioned it at the last meeting. This was the charge itself was going to be proposed to the Supreme Court. They will be covering this at their next meeting next week. And so this is the week of the 19th. And soon after that, once they review and approve the charge or make any modifications, a formal solicitation process will commence. And as soon as that happens, we will send an email to the deans, to the CBE for nominations. And let me tell you the categories which they wish to seek nominations from. So 2 former members of CAPO, the CAPO working group, 2 CBE members, a member from the NCBE testing task force, 2 members from the Council on Access and Fairness, 2 members from the California Lawyers Association, 2 law school deans, 2 judges, whether active or retired, a member from the California Department of Consumer Affairs, a current member of the State Bar Board or trustee, and a national expert on examination development or grading. So again, by next week, we will hear back from the court, and we will provide information on the formal solicitation process. Are there any questions? Okay, thank you. The next item, on the agenda is a report back on the October 2020 California bar examination, and Audrey will be covering that.
Hello again, everyone. Yes, last week we administered first ever remote bar exam on October 5th and 6th. Before going over some of the metrics I can share with you today, I just want to thank everyone, the admission staff. Was a huge lift to coordinate something that was so new and seemed to change a lot. We had to build a lot of the airplane while it was in the air. Also, the Board of Trustees working group, Alex Chan was part of that, so that was really wonderful to get advice in that manner as well. So there was a lot of folks involved in really making the exam happen, and I really want to thank everyone on the admissions team. I know a lot of them are admission staff, but are also in the attendee audience, so again, thank you for the huge lift. Just some numbers. So I believe the last time I gave a report, we talked about how many folks had applied for the exam. So at the highest peak, we had 12,017 applications. So that was not approved, but our approved number, the highest approved number we had was 10,355. And then because we had the full refund date of September 8th to get all your fees back, and then we also went through a couple different rounds of people needing to be withdrawn by administration. We had 2,704 folks that ended up being withdrawn either by applicants or by administration. So on Monday, on the 5th, we anticipated 9,762 exam takers. Of those, 9,623 were either doing the remote version of the exam, or 138 of those were on-site accommodated students who were using Exemplify, the software, but not having the remote proctoring, but having live proctoring. We also had 151 non-accommodated using the remote exam, but at our hotel sites, due to their extenuating circumstances, their need for a good Wi-Fi connection or a quiet place to test. We had 110 non-accommodated handwriters and 29 accommodated handwriters. So we had 6 in-person hotel sites, one in Sacramento, one in Burlingame, one in San Diego, and then 3 in the LA area. It was a totally new process for us due to all the COVID protocols in place, social distancing, temperature checks, going over with every applicant as they came to check in, a different set of questions, mask checks. Everyone who came to the hotel sites actually were in private rooms because of, again, social distancing, and we had new staff positions in place like COVID safety leaders. So that's the remote version of the test. Of all the applicants who downloaded the exam, so prior to the exam, you had to download all the exam files. 97.4% of those across both days were able to start their exam and get into the exam. On the first day, we did have, meaning ExamSoft, so ExamSoft had not just California, but 20 jurisdictions overall administering a remote exam. There was a hold time of around 15 minutes, and during that time, California, along with other jurisdictions, extended the time for folks to get into the test by 15 minutes to accommodate people who might be calling in, asking whatever question they might be asking, if it was a technical question or some confusion about passwords. So we were able to, during the test, extend the time for people to get in. So folks, again, that statistic of 97.4% of our test takers were able to get into their exam. I'll stop here if there's any questions, and I'll go into kind of next steps with what we do next about this unprecedented exam. Okay, well, the next steps for us are soliciting a lot of feedback. So we sent out this week to all the applicants a survey trying to get their feedback about all the ways that we communicated with them,
what worked and what didn't leading up to the exam, and then of course the exam itself, and how they felt about the exam. And we already have had a really great response rate on the survey to applicants. That'll be really important feedback as we're pivoting to the next exam very soon. We're also going to do a staff debrief, taking all that feedback from them about what it was like working on site at those 6 hotel sites. Next week, we should be getting back from ExamSoft the videos to review on our side. So as you might recall, ExamSoft uses AI and human review to look at flags, and then they come back to the state bar for us to review. So that hopefully will be coming back from ExamSoft next week. Any questions?
This is Paul. Angeli and I did request that we be allowed to observe, and I know she did. She can't be with us here today. I think she visited perhaps several sites in the LA area. I visited the Sacramento site and found everything to be proceeding quite well.
Paul, this is Esther. So Angeli visited USC, Pepperdine, and UCLA, and she just wanted me to make a note with the committee that, you know, overall she had a very positive experience to see how involved the schools were in helping their students. And based on her experience with Pepperdine, I believe that there was a message that Pepperdine had asked her to convey to the committee members, and that was that Pepperdine test takers were not clear as to when the actual time, the start time of the test was to start working on the essay, whether or not it was 8:30 or 9 a.m. So there was a confusion. Angeli's not sure how the confusion was later addressed, but overall, she was very pleased with her experience and seeing how everything was implemented. So really good job to everyone that took part in this process.
Thank you, Wes. And that reminds me, I also want to thank all the deans for opening up their law schools to their alumni to test. That was very helpful. And yes, in terms of the education and what we learned for password release times and when folks can start, I think I can't remember exactly, but right as soon as SA1 was starting, we put notes on our landing pages. We had several password backup pages that once you enter the password, you can start. So there was a long enough window, 25 minutes of, you know, giving people time to log in and make sure they're troubleshooting. But once you enter the password, you can start. There's no flag in the system letting people know. So I think that's going to be something for the next iteration, of which we have a remote exam. The remote first-year law students exam is in 1 month, November 17th. We're going to have even more lessons learned for how to extend information to applicants where they have no confusion for getting into the exam, where to find everything, and that they can start as soon as they enter the password.
All right, thank you, Audrey. All right, the next item that we're going to update on is a provisional license working group. And for that, we have both Paul Kramer and Dolores that are going to report back. We had a couple of meetings prior to this, I think, that they reported on, and one that happened this week. So with that, I will let either Dolores or Paul take it away.
Dolores, do you want me to start?
Dolores.
Why don't you let me do the background for any new members, and you can fill in the most recent activities. So in terms of the provisional licensing group, so I know we've got many different committees and groups working, so it's hard for everyone to keep everything straight. But so for background again, in mid-July of this year, the Supreme Court directed the State Bar to implement a temporary supervised provisional licensure program. And this was a limited license to practice law under the supervision of a licensed attorney. And of course, the reason for this was that this was to assist the 2020 graduates primarily who have been affected by COVID and who had either fear of exposure by taking the 2020 exam, or simply were suffering undue challenges, additional stress, whatever. So this was a means of assisting those graduates by giving them another avenue to work and get some experience before they committed to taking the bar exam. So that's the reason for this group. So working group was put together, and Paul and I from the CBE participated along with about 12 other people, I think. I'm not sure exactly how many were on the committee. And so this working group was supposed to develop the application requirements for this program, the eligibility requirements, what the responsibilities of a provisional licensed attorney lawyer would be, and the responsibilities of the supervising attorney. So we met twice, drafted the rules, and we were about to tie a nice ribbon around that and be finished when something else happened, and I'll let Paul go on.
Okay, and in a way we did, we tied a ribbon on at least phase one, because we did, after public comment, we sent forward rules for applying to the recent law graduates. And those, I understand, may be considered by the Supreme Court for adoption next week. But at the end of our meeting where we were considering the comments, another issue was raised by Neil Gupta, our representative from the Chief Justice's chambers, and that was the idea of adding law graduates who had scored above the newly enacted cut score in the last undeterminate number of years to also participate in the program, and perhaps somehow allow them after participation to become lawyers without passing the bar exam. So we scheduled another meeting that was earlier this week on Wednesday to discuss that. We did decide in that group to allow them to participate in the program, but the question of how and if they might also be able to avoid retaking the bar exam by virtue of their participation, we could not come to a conclusion on that. And so we are in the process of picking a date for another meeting to continue that discussion. But it's my expectation that the original program, assuming that the court is happy with what we gave them, might be approved next week and might go into effect fairly soon, with this other aspect added on at some later time.
Any questions from the committee? Great. Thank you, Dolores, and thank you, Paul. Right, and the next item under my time is the February 2021 California bar exam. Audrey, I think you have an update.
Yeah, so right before the 5th and 6th administration, so on October 1st, we opened up applications for the February bar exam, which is scheduled for February 23rd and 24th. It is right now open only for remote administration. And as of yesterday, we have 378 applications so far for that February exam. That's all for now.
I have a quick question.
Sure.
Okay. So for as of today, I guess per the guidance that we received from the Supreme Court's justices, we are still going with the remote exam. Or is that open to change at any point throughout the next couple months?
So I'll take that, Audrey, if you want. This is Donna.
Hi, Donna.
We would expect an ultimate direction from the Supreme Court on whether or not to be doing the exam remotely. I think the court was continuing to evaluate the pandemic conditions and certainly wanted to see how the October administration went before issuing a direction, but I would expect them to give us a clear direction on the remote exam approach. I would think it's fairly likely that they would sort of acknowledge the use of a system similar to what we did this time, where we had primarily remote, but the opportunity for in-person for those who couldn't meet the testing conditions that were required or had extenuating circumstances. But obviously, I certainly cannot speak for them.
Okay, so back in reference to the provisional license working group, does that mean there's a potential that the Supreme Court could offer the February cohort or administration provisional licensure as well?
The February 2019 exam cohort or the upcoming
2021 cohort?
So right now, the eligibility criteria for the provisional licensing is anyone who was graduated between December 2019 and December 2020. So, it's not contingent on which a bar exam you sat for, rather it's about whether you're part of that graduating class.
Okay, but it's also open up to the Supreme Court justices potentially expanding it if they deem it necessary. Do we know more or less when a decision will be made or when there will be an affirmation of the process?
So Paul mentioned the meeting is next week, so I believe it's going to be discussed by the court next week.
Thank you so much.
All right. So Esther, I think we're done with the director report.
Thank you. So we're going to move on to examinations, and this will be Lisa Cummins and James Efting on the approval of technical report.
Thank you. So I don't know, Jim, if you want to take this or you want me to.
I'd like you to.
Okay, happy to. So after the administration of every first-year law student's examination, the results are released. The committee's psychometrician, Dr. Roger Bolus, does produce a report on some of the information, a technical report, which is attached to this agenda item for your review and approval, the committee's review and approval, and that would be what the motion would be is a suggested motion to approve and receive and file the report. And I'd be happy to take any questions anybody has with regard to the report.
Lisa, my question was, were there any anomalies here that we should point out to the committee? Anything that was significantly unusual this year from other report tests?
I don't think so. No, I mean, this was the first remote administered first year exam. It was kind of the canary in the coal mine for the bar exam, but nothing with regard to the technical aspects of it that I know about or that I believe were reflected in this report.
Okay, that's good to hear. So I guess we would say, does anyone make the proposed motion?
And just to be specific, the motion would be to approve the technical report and have it be received and filed.
Correct.
Any motion? Any second? I think someone made a motion.
Who made
the
motion?
If I can, I'll make the second.
I'll make the motion for approval. I didn't hear a motion, but I'll make the motion.
Okay, so
Jim Epting will second.
thank you.
And the
Roll
motion
call,
to
please.
receive and file, I believe, right? Or
Yes.
okay.
Dr. Bolton? I know Dr. Bolton is here. So Dr. Cow?
Yes.
Mr. Chen?
Yes.
Mr. Epting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Mr. Iseri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Pick?
Yes.
Mr. Reyes?
Yes.
Mr. Torres?
Yes.
The motion passes.
Thank you. So our last item on the open session agenda would be educational standards. This will be presented by Paul and Natalie. Keeping in mind that this will probably be a lengthier item, I'm hoping to take a break around noon for half an hour. So just keep that in mind as we proceed through this item. And I'll turn it over now to Paul and Natalie.
Okay, thank you. I'm going to try to avoid repeating most of what's in the staff report. And I'll remind you that we did have a presentation on some of the fundamentals that underlie this effort to revise the rules that apply to accredited law schools at our last meeting, where you put the item over for further review by a small working group consisting of Michael Cow and I from the committee. And we have spent a lot of time working on it since. We have a draft proposal to you. In a while, I will talk about some additional revisions that we want to recommend, but so that you can start looking at them if you want. If you look in the chat window, and this should apply both for members of the committee and also members of the public who are with us on Zoom on their computers, Natalie has posted a link to the document that we created yesterday that shows some amendments that we are recommending in addition to what is before you in the main agenda item for 0400. So I have it's not a PowerPoint, but I have my talking points that I will share to help you follow along with my presentation. So let me do that. Can you tell me if the size of the text is such that it's readable?
Yes. Good.
Good.
Okay, not too big or too little? Okay, thank you, Goldilocks. As you know, this process has been going on for a while. Its genesis is from Appendix I. Sorry, I need to... The share took over my screen and I can't see my notes, so hold on. Oh, that's really odd. Okay.
Or Paul, alternatively, I can share this document for you so you can access your notes. It's totally up to you.
No, I've got it now, I think. You can see, Jesus. Yeah, why don't you share it? Because it's causing me technical grief over here.
Paul, are you referring to the revision memo or the updated proposal to replace the rules?
I'll get to the revision memo in a bit.
Okay, all right.
But if you want to take a look, my hope was that we could distribute this ahead of the meeting, but that just there wasn't time to do that. And had we been able to do that, I would have said to you, take a look, see if you see anything you want to talk about, but otherwise I wouldn't spend time going over it. But depending on your feelings in a few minutes, we may or may not need to do that. So the genesis of this effort comes from Appendix I, where where various changes were made to the organization of our advisory groups, and also to our duties. One of the possible outcomes of Appendix I was that our accreditation function could be fully outsourced to some other accrediting agency, what we're referring to as the regional accreditors in most of our conversations. But as you can see from the excerpt there, and this is from the staff recommendation to the Board of Trustees, it was determined that just wasn't possible to completely outsource things. So what the trustees did instead was they directed CS BARS to work with staff and our committee to identify our requirements, our accreditation requirements that are fundamental and that must be satisfied in order for schools to continue to operate here in California, and to basically waive the requirement that we conduct visitations and inspections of schools in favor of having that be done by the other accrediting agency. At the time the board was discussing this, they used the term deemed approved, but I for one strongly felt that was a misleading term, because it suggests that if somebody gets approved by another accrediting agency, such as WASC, for instance, then they can just come to us and say, I'm an approved law school for your purposes. And that is not our intention. And I would hate for some applicant to a law school like that to get the wrong impression. Thus, we changed the term, the label applied to these schools that are accredited both by us and another agency, to jointly accredited. And those jointly accredited schools will have to comply with what we call the core requirements. You can see those in Rule 4.147C1 on page 17 of the main staff analysis for today. But other requirements that we make of schools that are just accredited by us and not jointly accredited would not apply to them. Again, they would not be subject to the periodic inspection by the Committee of Bar Examiners, but instead would be inspected by the other accrediting agency. If we did find cause to suspect a violation of a core requirement, though, we could request additional information and even an inspection in those circumstances. We can only discipline the schools for violations of the core requirements. The assumption is that for the non-core requirements, the requirements of the other accreditor will be sufficient to effectively enforce them for us, and we don't need to specifically apply them. A concrete example of this is the consideration and approval of major change requests. That requirement would no longer apply to the jointly accredited schools. Staff believes that, again, the other accreditors' requirements would assure that such changes are given appropriate scrutiny. And in the, I would think, exceedingly rare case that something was approved that violated the core requirements, we would still have the ability to take action to address that. I do wonder, though, whether all potential accreditor standards will be as rigorous as we are assuming based on our examination of the two that are most likely to accredit our schools. Also important to note is that 14 of our currently accredited schools appear to be eligible for joint accredited status as soon as the rules go into effect, in that they are already accredited by another accreditor. The draft that you have before you was sent out to the CS BARS members. Oh, Natalie, you need to be scrolling along with me. We sent the draft out to the CS BAR members a week ago in preparation for their meeting on this past Wednesday. And Dr. Cow and I attended that meeting, me and my new role as our representative to them and on that committee. And we received comments from the members. I want to thank the committee, that committee, for reordering their agenda so that we could discuss their comments before I had to jet off to the provisional lawyer licensing working group meeting. We did review those comments in the short time that we had, and they resulted in several minor recommended changes to the draft rules, some to clarify perceived ambiguities, and a couple that provided greater flexibilities to the schools. Again, I hope to just get those, I would be able to get those out to you so you could have a chance to look at them before the meeting, but we just simply didn't have time for that. But you do now have the link to them and you can look at them. And again, for anybody who's listening in the audience, if you go to the chat window on the Zoom system, you will see a link that Natalie has posted there. There are, I believe, remaining significant, well, there are other significant rule changes that were made. Those are summarized, as well as points of disagreement between staff and the schools. That's in attachment B of the staff report, which begins at page 34 of the PDF file that we have. I'll highlight just a few, and we can discuss the others upon request, but I don't want to take up a huge amount of time. One issue is phasing of the new rules to the extent they make changes. By and large, they relax requirements. They make them less specific and more performance oriented. But to the extent that a school needs time to come into full compliance with any new or changed requirements, our group, that's Michael, Dr. Cow and I, and staff are thinking that we would address that in guidelines that we would be preparing shortly after we end our work on this, the rules themselves. And we have in mind a 2-year window for existing schools to come into compliance with any new requirements, with the possibility of additional time if it proves reasonably necessary for a specific, but not all, new requirements. And the guidelines, of course, will come back to you at a later time. So you're not committing to anything today. I'm just, I'm trying to, in effect, tell the schools what we're thinking, at least among the two of us in that regard. But they will be able to participate in the review of the guidelines themselves at a later time. The schools have also said, and they said it again on Wednesday, that we have too many requirements that we've put into the core requirements category. I'll note that jointly accredited schools are being relieved of one inspection, one periodic inspection. They don't have to be inspected by us and their other accrediting agency, but just by the other accrediting agency. And also we're not going to be requiring them to submit their major changes to us. They will do that through the other accrediting agency. So, I mean, there are trade-offs. Understandably, they want the maximum amount of flexibility and autonomy. The new rules increase that, I guess not to the level that they would like. But it's certainly my belief that this Committee of Bar Examiners and the bar must retain the ability to intervene if fundamental requirements are not satisfied. And my definition of fundamental includes more than just satisfying the MPR and providing some notice of for instance, that your law degree from this school may not make you eligible to take the bar in states other than California, and other information that is important to convey to prospective and current students. The schools also requested the ability to implement what they call competency-based education, in which one may pass a test to show mastery of a course's materials and get course credit without taking the class. As proposed, the concept, in my opinion, is not sufficiently defined for us to evaluate or review its implementation. If the committee is interested in exploring this concept, further study seems appropriate, but this should not hold up the adoption of the revised rules. We can always add that later. We have a sense that some schools would like to have fixed facility classes outside of California, possibly even outside of the country. Our current policy prohibits that, and it is carried forward into this draft. This might be a topic the committee wishes to discuss today, but as it is, we've left the standards as they were. And then finally, the compliance process. The school's proposed compliance process that has more steps and would be lengthier than what is in the proposal before you. We have streamlined it to begin with a notice of noncompliance, followed by the school's response and their option to request a hearing before a panel of 3 CBE members. The committee will then decide either on the school's response and the record before it, or based on a recommendation from the hearing panel, if there is a violation, and if so, what the appropriate sanction would be. It's most likely to be probation, but there is a potential, and we are allowed to immediately terminate accreditation in cases where that is warranted. Near the end of the probationary period, the committee will consider whether to terminate accreditation or end the probation, again with the option for the school to request a panel hearing before the full committee considers the question. The panel hearing is offered to allow a fuller presentation of evidence and argument than might be feasible at one of our full committee meetings. Finally, just want to emphasize the action we take today is not the end of this process. Our recommendation goes to the Board of Trustees. They decide whether to send it out for public comment. Then it comes back to the bar for final action. As we are deeply involved in the development of these rules and will be charged with administering and enforcing them, I recommend that we specifically request that the trustees route the public comments back through us so that we can review them and offer any appropriate additional recommendations after our review. So with that, Natalie, did you want to add anything? And then I asked her, I guess, to leave it to the committee to tell us what specific questions they have or issues they want to put on the table for full discussion. But the recommended action would be to approve these rules with the revisions that are in that memo that we've just given you a link to, and modify the request to the Board of Trustees to be clear that we want to have a hand in reviewing the comments rather than, because as I understand it, sometimes it would go directly back to the trustees and we wouldn't be involved in considering the comments. And there may very well be some, for instance, some minor corrections that are well taken that we would want to make, but I think we're best positioned to do that.
Because we discussed it at length in August, I would turn to the questions of the committee, if there are any, so that we can focus the discussion on where their concerns might be.
I don't have any questions. Just wondering if there is going to be I guess in our adjusted meeting schedule or layout, do public comment come before or after, or is that done at the beginning of the meeting?
We've received public comment at the start of the meeting on all items, including this, and we did receive public comment from Dean Jackie Gardina on this. There might be less public comment than you expect for an item of this magnitude. And I can't speak for that, but part of the reason may be because the staff proposal, which is has now morphed into the updated proposal, was posted back in August, was available during the month. Dr. Cow and Paul Kramer met weekly during the month. There was a Q&A session with Dean Gardina and Dean Pritikin. The materials were posted last week. They were discussed over a 2-hour meeting with CS bars at length. And so there has been a lot of comment incorporated even just within this most recent 6-week period.
You got it. So if there's no other comments or questions from the committee, I'm willing to make the motion, but I will see if anybody else has any comments to add or questions.
I have one quick question. So the attachment B lays out, it is laid out as though there's recommendations from CBARs that are separate or different from the updated revisions. I guess my question is, does this represent a consensus of the entire CBARs group?
No, I think it's fair to say they would like some things that this does not give them. At least they have said so in the past. I mean, I won't purport to speak for them, but the table was intended to try to lay out the. In some places, what Natalie did was explain a change, and there's really no controversy about it. But in others, it's attempting to explain the different positions of the bars and staff. And we actually allowed Dean Gardina and Dean Pritikin to write text to go in there. My purpose in asking staff to prepare that was to try to lay out the issues, because there were a lot of complexities in a way that would make it easier for us to understand and digest. I hope it achieved that purpose, but you know, of course, nothing is ever perfect.
Loris, during the drafting process, because this was a large undertaking rather than a specific section, the drafting process proceeded with a usually 4-column chart very much like this. And on different topics, we would show the staff proposal and the CS bars proposal, bringing them together where we could, and then ultimately determining some points where a staff alternative might be recommended. And so in each case where there wasn't a complete consensus, the difference is noted in that chart that you see. So the first section is the CS bars proposal only. It compares it to the updated rules proposal that you have now. So not what was originally proposed by staff, but what was further modified by Paul and Michael.
Okay, thank you.
Mm-hmm.
So I'll move for adoption of these rules. And I believe we're sending this to the Board of Trustees. So I don't know if there's a particular motion that needs to be made, but I'll make the motion.
I'll second.
May I clarify that this would be the motion posted with the amendment of the changes suggested by Kramer and Cow posted in the chat? Is that what you intend, Paul?
Yeah, I'd also like to include the request that the Board of Trustees route the comments back through us, just to be specific about that.
So just to clarify, my motion will be to submit this for review to the Board of Trustee and for any additional revision comments to be submitted back to the CBE for consideration and ultimate adoption.
I'd say public comments instead of revision comments, but yes.
Okay, understood. I accept that and good to go. So move.
I'll second.
Roll call vote, please. Second by David Torres.
Okay, thank you. Before I take a roll call, I would like to welcome Judge Herman. Judge Herman, welcome to the Committee of Bar Examiners. He just joined us. Dr. Cow?
Yes.
Oh, Dr. Bolton? Mr. Chen?
Yes.
Mr. Efting?
Yes.
Mr. Gongora?
Yes.
Ms. Heisinger?
Yes.
Judge Herman? Mr. Iseri?
Yes.
Mr. Kaplan?
Yes.
Mr. Kramer?
Yes.
Mr. Lawrence?
Yes.
Ms. Pitt?
Yes.
Mr. Reyes?
Yes.
Mr. Torres?
Yes.
The motion passes.
Esther, I just want to thank Dr. Cal, Kareem Gangora, Natalie Leonard especially, and the members of the CS bars for all the hard work they put in the development of these rules and for their participation and dialogue that I was able to engage with them in the last month and a half.
Thank you, and thank you also because I know that you spent a lot of time in learning this and doing this. And the timing's perfect right now, actually. This actually concludes our open session. So committee members, after our lunch break, which will end at 12:30, please please join the closed session. And public members, we will rejoin the open session to formally adjourn the meeting upon the completion of the closed session. At this time, committee members will take our lunch break and just please join the closed session at 12:30. Thank you. The meeting business has concluded, and is there any more business that anyone needs to address? Seeing none, the meeting will be adjourned, and thank you everyone for your patience. See you all in December, and stay healthy and safe.
Thank you, Esther.
Thanks.
Thanks, Esther.
Bye.